Hello, hello, hello. How is everyone doing today? I'm here really quickly to do a really short question and answer session. I want to talk about a question I get all the time, and I'm talking about domestic violence in honor of October, which is Domestic Violence Awareness Month. All right, this is a month that is dedicated to educating um, and raising awareness of domestic abuse and helping people who are victims of domestic abuse. So, how's everybody doing? If you join on, please uh, leave a hello, hi, wave sign so that I know that you guys are here with me. Okay. So I get this question all the time, all the time. Um, whether can I file for Violence Against Women's Act if my I-130 has been denied? So let me introduce myself for those who are just joining us and who have never been on my live before. My name is Ifeoma Odulami. I am an immigration attorney with the Odulami Law Firm. Our office is in New Jersey, but we serve clients in all 50 states. So this is a really important topic. So please feel free to share, subscribe to my channel, like, so that when I come on, you are immediately notified. So let's start from the beginning. VAWA is Violence Against Women's Act. It applies to men, women, children, people who are in a relationship with a U.S. citizen or green card holder, either a relationship of marriage or a family-based relationship, a child or parent who are being abused in some manner, either as a physical abuse, psychological abuse, verbal abuse, or whatever. But for today's purpose, I'm going to talk about spousal abuse, because this is a question I get for a lot of people who are married to U.S. citizen or green card holders. So basically what happens is they file an I-130 petition, which is an immediate relative petition, and they go through the process, get to the interview, and they are denied. And now they want to know if they can file for VAWA after the denial. So the answer to that is yes, you can. Now, it would depend on the facts of your case. It would depend on why you were denied. So a lot of times, the reason people are denied is because one, maybe the U.S. citizen spouse or green card holder spouse does not show up to the interview, right, as part of the cycle of abuse, right? Or the U.S. citizen or green card holder spouse um, goes into the interview with the intent of sabotaging the interview, right? Giving wrong answers purposefully to hurt their immigrant spouse. Or during the process of putting the paperwork together, they refuse to give them the paperwork that they need to create, to show a bona fide marriage, such as they refuse to give them maybe information to show that they, the U.S. citizen or green card holder, are a qualified relative. Or maybe they refuse to open joint bank accounts. They refuse to file taxes, or they withhold important information that only comes out at the interview, right? For instance, how many children do you have? Maybe they never quite told their spouse that they have two kids from a different relationship that they never talked about. And then it comes out at the interview, and then it looks like, the spouse, did not know enough about her U.S. citizen or green card holder spouse, and that creates a question in the officer's mind whether it's a real relationship. So, so there are many things that an abusive spouse can do to derail your immigrant visa petition. Sometimes they could even threaten to call USCIS, and sometimes they even may call immigration to report that it's not a real marriage, right? Sometimes they may call the police, or just put you, or call even Division of Child Protective Services to to put you in a position where you're afraid that if you don't do what they want you to do, then you're going to get in trouble with the authorities. So the question is whether you can file a VAWA petition when your I-130 has been denied. And yes, you can. So if your I-130 has been denied, you can file a new VAWA petition by filing the form I-360. And if you're able to adjust status and you have no inadmissibility issues, you can file another I-485-765-131-I-864W, right? You can do that, right? If you have some inadmissibility issues, it would depend on what that issue is to determine whether you can, you can adjust status or you can file a waiver, a 9601 waiver. Okay. So knowing that, I tell people that the first thing you need to figure out when you want to file a VAWA petition after filing an I-130 petition is to figure out why your case was denied, right? What was the basis for the denial? Because you have to address that when you're filing a VAWA petition. If the reason for the denial is that you didn't have enough documents, right, to prove a bona fide marriage, you want to be able to explain why you didn't have enough documents to do that in your VAWA filing. You want to be able to explain that it was possibly part of the abuse, right? The U.S. citizen abuser or green card holder abuser refused to give you this information, or they at the interview they threatened you that they were going to sabotage the interview by giving wrong information. So you want to know why you were denied. Now, do you have to wait to file the VAWA until you get your denial? No, you don't. It all depends. And that's why it's a good idea to talk to an immigration attorney who will possibly file a FOIA, Freedom of Information Act, to get all your records, or who can interview you to figure out what needs to be done based on what the information you're giving them. So now I tell people, and this is really important because a lot of people believe that because they have an I-130 pending, a petition by their relative, that they have to see it through till the end. You don't have to. If you're in a relationship that's abusive and your spouse has already put a petition in for you, you don't have to continue with that petition. You can actually file the I-360 and abandon the I-130 petition, right? So you can do that and ask for an abeyance of your adjustment of status application, which means that they will move the adjustment of status application from the immediate relative petition to a VAWA petition. And that actually saves you $1,225, which means you don't have to file for another adjustment of status. They just move it to a VAWA case, and when your VAWA is approved, then you go for the adjustment of status interview. So it's just important. I bring this information up here because even though I talk about VAWA all the time, I'm always surprised that there are people who are living in fear because they don't have this information that can get them out of this bondage. So it's really important for you to share this video. You need to put it out there for people who don't know. You know, there are a lot of people who are not on Facebook, so they just may not know, or people who, for one reason or the other, they haven't really heard this. So now, the other question that I get all the time is, do I have to stay married to get my VAWA case approved? The answer is unequivocally no. You do not have to stay married to your abuser to get your VAWA case approved. The only thing you have to realize is that you have to file the VAWA petition at least within 2 years of a divorce. If you decide to get a divorce, right? You must file that so that you're not precluded from filing. So now, do you have to live physically with that person when you file your VAWA application? No, you don't. You can choose to live with them, because some people have to stay with their abuser because of reasons, financial reasons, they can't afford to leave, or maybe it's just not the right time for them, right? But it's your choice. You can stay with them, or you can leave them and move on with your life. But whatever you do, I want you to have your safety paramount. Your safety is the most important thing. If you don't feel safe in that environment or with that person, please get out. There's help, and I think, let me give you the number for the domestic violence line. It's 1-800-899-7233, or SAFE, SAFE, SAFE. So if you do not feel safe, please make a call to that number. If you do not want to call that number, find somebody who can take care of you while you're looking for somewhere else, right? if you are looking for domestic shelter, there's physical abuse and you're looking to get a domestic, to get into a shelter, there are resources out there. You do not need to stay in a relationship where you do not feel safe. Now, if it's a relationship where it's emotional, psychological abuse, you can also get out of it, right? Just know that you have resources that can allow you to get out of this relationship, right? And the great thing about VAWA, I tell people all the time, is that the law, the Violence Against Women's Act law, uses the trauma that you're going through to give you hope. So because of the abuse that you suffer in this relationship, you can get a green card. You can have a pathway to a citizenship, right? And VAWA is so different from other parts of immigration law, because the burden of proof on you as a victim really just requires credible evidence that there's no requirement for you to produce a police report. There's no requirement for you to produce anything but credible information, right? And of course, when you provide information, it's more credible when you're able to back it up with maybe somebody's affidavit, or maybe even just your story describing how everything went, right? So, but I always tell people, with regards to filing a VAWA application, you really want to go to an attorney who does a lot of VAWA cases, because it's a very specific area where, there are a lot of moving parts, right? And you want to make sure that you've gotten the information that you need to be able to to file a successful VAWA case. So let me look at some of the people who are signing in. Hi, guys. Mr. Tusk says, good day, attorney. So actually, I should put this here because, okay, Mr. Tusk says, I'm a 2-year green card holder and I was a victim of domestic violence. I'm so sorry to hear that, Mr. Tusk. You say you filed for divorce. Can you still get your green card without your spouse? And how do you go about that? Can you file once you finalize your divorce ASAP? Mr. Tusk, first of all, I'm so sorry to hear that you're a victim of domestic violence. And yes, unequivocally, yes, you can file to remove the conditions on your green card. That's what you mean by saying that you have a 2-year green card. That means you have a temporary green card. So to remove the conditions on your green card, there are 4 waivers. And what that means is you don't need your spouse to get that green card. And I'll talk to you about the 4 waivers. There's a waiver of divorce, which I think you know. So if you get a divorce, you have to be able to show that your marriage was a bona fide marriage, right? So you can put in the divorce decree, and then you have to also upload information to show that it was a real marriage at the time you got married. At the time you entered into the marriage, the intention was to have a real relationship, to be with a person. Now, there's also the waiver of abuse, which is similar to the VAWA, right? You have to show that you suffered some sort of abuse. It can be physical abuse, it can be emotional abuse, it can be financial abuse, it can be sexual abuse, it can be psychological abuse, right? You have to show that. And of course, as always, you always want to show that it was a bona fide marriage, always. Because as I tell people who come into my office and they want to file a VAWA when their spouse, is, not treating them well, I always ask, is this a real legitimate marriage? Is it a bona fide marriage? Because that's the first step. And if you can cross that step, then we move to the next step of showing the abuse, right? Now, the third waiver would not apply to you because it would be death if the U.S. citizen or green card holder died. And the fourth waiver would be extreme hardship, right? You have to show that deporting you or sending you back to your country will cause you extreme hardship. So in your case, Mr. Tusk, if you want to go ahead and finalize your divorce, go ahead. If you're going to do a waiver of a divorce, remember that the divorce has to come through before, so that you can be granted that the permanent green card. So, but I feel that you could use 2 waivers, Mr. Tusk. You could use a waiver of divorce, and you can also use the waiver of domestic violence. And I'll tell you the pros of each, right? Well, the advantage of using a VAWA type waiver is that after 3 years of having your green card, you can file to naturalize, right? But if you get the divorce if you get the waiver under the divorce waiver, you have to wait 5 years. You have to have your green card for 5 years before you can file to naturalize. So either one works, but another advantage of filing with a VAWA type waiver is you don't have to wait for your divorce to be approved to be able to, know that you're going to be successful at the interview. So if you file the VAWA type waiver, it doesn't matter when they call you for the interview. You're not under pressure to make sure that your divorce decree is approved before you get for the interview. I hope that answers your question, Mr. Tusk. And if you need assistance, please call us. Let's help you. 973-993-1900. We do a lot of green card conditional removals. All right. Now, the next person is Alaji So. Alaji So says, good afternoon, Ifama, the best lawyer. Thanks for everything you're doing to educate immigrants. You're so welcome, Alaji, and thank you for calling me the best lawyer. And then I have Yetunde Abimbola saying, can you file adjustment of status when your case is still pending in the court and you already have your prima facie? Well, typically, Yetunde, if you file the I-1-360, which is a VAWA, you could have also filed the adjustment of status at the same time. You could do that, right? Unless you're, there's a reason why sometimes you can't file an adjustment of status because of inadmissibility issues. And in that case, well, then you don't file the adjustment of status. But let me assume that you file the I-360 because I think that's what your question is suggesting. You file the I-360, but you didn't file the adjustment of status at that time, right? Now, you can still file the I-485, the adjustment of status, while your I-360 is pending. In the I-485, there's a portion where it asks you for that information, the basis for your adjustment of status, and that's where you would put the information that it's based on filing a VAWA petition. All right, and Mr. Tusk says, awesome, thank you so much for the insightful information. You're welcome. So guys, I wanted to run in real quick to give you this information. I'm going to be talking a lot about VAWA, SJIS, Special Immigrant Juvenile Status, U visa, T visa, because this month, October, is Domestic Violence Awareness Month. So with that, I'm going to sign out because I don't think there's any more questions. And I want to wish you guys a great weekend, and I will be back on Monday. Take care.